All right, great. So good morning. Thanks for joining us. This is Ray Rodriguez and Matt Freeman of Lucrum Real Estate Group. Lucrum is an apartment brokerage sales team that assists multifamily investors with selling and acquiring apartment buildings in the greater Los Angeles and Southern California markets. Today, we are joined by the Howard Jarvis Taxpayers Association to discuss Measure ULA transfer tax and the lawsuit against the city of Los Angeles, challenging its legal validity. Measure ULA is set to impact many Los Angeles real estate investors and homeowners beginning on April 1st of 2023.
And now we'd like to please welcome Susan Shelley, the Vice President of Communications, and the Director of Legal Affairs, Laura Doherty, along with John 𝗃𝗂𝘀𝘀𝗀𝗀𝗃, the President of the Howard Jarvis Taxpayers Association, which is California's leading taxpayer advocacy group. For those of you who are unaware, the Howard Jarvis Taxpayers Association has joined the Apartment Association of Greater Los Angeles in filing legal action against the city of Los Angeles on behalf of taxpayers in regards to the recently passed Measure ULA, the mansion tax. Now, this is going to be a Q&A session. Please feel free to share any of your questions in the comment box, and we'll try to get to as many of those as possible at the end of the webinar. So as we get started, Susan, Laura, and John, thank you for joining us today. Tell us a little bit about yourselves and your role within the organization. And I guess we can start with Susan.
Well, thank you. It's a pleasure to be here. My name is Susan Shelley. I'm the Vice President of Communications for the Howard Jarvis Taxpayers Association. HJTA, if you're not familiar with it, was founded in 1978. This is the organization that brought you Proposition 13, that put it on the ballot and that fights for it to this day against all of these efforts in the courts and the legislature to punch holes in it. We fight on the ballot everywhere. We fight constantly to make sure that the taxpayer protections that voters approved are protected. So that's what I do. And let me introduce the president of the Howard Jarvis Taxpayers Association, John 𝗃𝗃𝘀𝗀𝗀𝗃.
Thank you, Susan. Yeah, I'm John 𝗃𝗃𝘀𝗃𝗀. I am an attorney. I came to California in 1982, spent 10 years with the Pacific Legal Foundation, a conservative public interest law firm specializing in property rights, and then transitioned, became the chief litigator for the Howard Jarvis Taxpayers Association. We have offices in Los Angeles, and we have 5 people up here, 3 attorneys up here. We're kind of a full service organization. We not only do the litigation through our 501c3, but obviously we do lobbying through our C4. We have 2 initiative committees, Protect Prop 13 and No Due Taxes, that are registered with the Fair Political Practices Commission. We have political action committees, and we engage in endorsements. Again, we try to advocate for taxpayers in every single arena that we can. So I said, I'm an attorney. I graduated from William & Mary Law School, and but have not been directly involved in litigation. For that, we hire people who are a little bit more up to speed right at this point, like Laura. I am the principal drafter of Proposition 218, the Right to Vote on Taxes Act, which added Article 13C and 13D to the California Constitution, granting Californians pretty broad rights to approve, either at the ballot box or through other processes, additional taxes, fees, charges, and assessments. So with that, I will turn it over to Laura.
Good morning, everyone. It's very nice to be here. Thank you so much. Yes, like John, I have worked at the Pacific Legal Foundation. It was brief, my stint there. Then after that brief time, I was able to work at the private spin-off law firm run by Ronald Zumbrin. So doing property rights there. And after that, I worked on my own for a bit, and then I was able to come work at Howard Jarvis Taxpayers. It's been about 6 years now. Best job I've ever had. Very much enjoy this work. So as Director of Legal Affairs, I get to look at all kinds of things for protecting taxpayers and voters, everything from special taxes, pension obligation bonds. And now I think this mansion tax case is going to be one of our biggest cases. This is pretty serious. So I'm glad to be here today to talk to all of you about it.
Well, thank you all for joining us. Before we get into the Q&As, I was just curious, this is a 501c3. How are you guys actually funded? Because this is very expensive endeavors to take on both the city of Los Angeles and sometimes California.
Right. Well, thank you. We are fully funded by our members. Howard Jarvis started out the primary membership of HJTA back in 1978 was just basically homeowners trying to hang on to their homes. As we've evolved and matured as an organization, most of our members are still primarily interested in defending Proposition 13, but as we've grown, obviously we've expanded our membership to other interests. I will say that apartment owners were there at the beginning because Howard Jarvis himself was the executive director of the Apartment Association of Greater Los Angeles. So we've always had that close alliance with apartment owners, but we are a dues-based organization. And for our larger donors, oftentimes the 501c3 is the better option because of the tax deductibility. But of course, funds received into the 501c3 cannot be used for political purposes. It can be used for litigation. I will say at the outset, though, that gifts to the Howard Jarvis Taxpayers Foundation cannot be earmarked for a specific item of litigation. But if anybody likes what we do generally, and I can't think of any cases that we're currently involved in that would be contrary to the interests of people on this phone call. So again, I think we can talk about the cost of this litigation at a later point in time, but obviously would be very appreciative of any financial support that we get through the C3 or the C4, whatever moves people to give to the organization.
That's fantastic. On that note, if one of you from the Howard Jarvis team can put in the comments an email or some sort of contact information in which any of the visitors that are here today want to share, so that they can get in touch with you if they're interested in donating to the cause of real estate owners and investors, please do. So, we're really excited to have you today because in a time in which landlords, homeowners, investors feel like essentially everything is working against them, and I hear a ton of complaints, I hear a ton of frustration. Here's the group to help you. And so we're so happy to have you because it's not hopeless. There are good people out there like yourselves looking to help the homeowner and the real estate investor. So thanks again for being with us today. And I'm going to go ahead and jump into the first question now. So please explain what Measure ULA is as simply as possible and what property types are impacted.
Well, I'll be happy to answer that. This is a tax on high value real estate. It's a transfer tax. So at the time that it's sold, property that sells for between $5 million and $10 million is taxed at 4%. And property that's valued at $10 million or more is taxed at 5.5%. And that is just on the sale price. That's regardless of whether it's underwater or it's profitable or nothing else matters. It's just essentially a sales tax, and the money is dedicated to the special purpose of creating affordable housing and fighting evictions and tenant protections and that sort of thing. So this is a special purpose documentary transfer tax on high value real estate. They called it a mansion tax. It's not just on mansions. It's on apartment buildings, office buildings, strip malls, shopping malls, movie theaters, self-storage facilities, any property at all in the city of Los Angeles that sells for $5 million or more.
I had a quick question about that. Is that a 4% additional transfer tax on top of the already transfer taxes we pay? So it's not just 4% transfer tax, it's in addition to the traditional county and city transfer taxes you're paying.
Correct. And it goes into a particular special fund to be the payment, the spending is directed by a board of governors or a board of directors that's appointed specifically to administer this tax.
Now, are these people elected or are they just appointed?
They are appointed and they are unaccountable.
Wow. So these are unelected people in charge of our taxes.
Yes,
Gotcha.
and it's estimated to be about $800 million a year, maybe more. And all of this money is dedicated to the purposes that were listed in this initiative. Not $1 of it can be used for temporary housing or emergency shelter. So as far as getting people off the streets right now, it won't do anything. It directs the funding to basically the type of affordable housing developers who funded the initiative. They directed the money to themselves.
Got it. You hinted at the second question a little bit, and it might be a silly question, but it's a question nonetheless. Why was Measure ULA referred to as the matching tax when it impacts so many other property types, including commercial real estate?
Polling, marketing, politics. If they said
Mhm.
it was a tax on apartment buildings, it would have been perceived very differently.
Or a tax on everything.
Right, or
Yeah,
tax on
all real
everything,
estate.
yes.
Yeah.
Right.
Yeah.
Okay. If you could please explain the lawsuit and the plan for challenging a measure that was actually already passed by voters.
I'll turn it over to Laura for that.
Yes, I can take that one. Well, HJTA was the first to file its lawsuit. I'm sure we've heard that there are multiple lawsuits now, but we were the first to file just before the holidays. And we kept our case very simple. From the very first time we heard about Measure ULA, we were aghast because it is contrary to Proposition 13 itself. Proposition 13 has a section which specifically says there can be no tax on the sale of a property. And that is because a government is not supposed to be able to try to get all the money at the end of your ownership period that it thinks it should have gotten while you lived there or while you ran the apartment building or your business. So that's one of those things that was supposed to be very clear, and it's still there. In the early 1990s, the courts did carve out a small exception to that, and they carved it out for charter cities. So of course, Los Angeles is a charter city, but the exception is only for general taxes. So in our lawsuit, we have Measure ULA, which is, everyone agrees it's a special tax. It is a special tax because it is dedicated, it is earmarked for housing and homelessness services. Now, even with those exceptions that the courts carved out in the early 90s, the courts were very clear that Proposition 13 says no special transfer taxes by any government. So we have this very firm basis in Proposition 13 that there can be no special transfer taxes, and they're just substantively illegal. So that's the first part of our lawsuit. Now, secondly, we have had to contend with what's become known as the upland issue. And I'm sure many of you have heard of this, but I'll try to give it a brief explanation.
Can you repeat
here.
that? It was the what?
The upland issue. There was a case that's become known as the upland case, and there are taxes becoming known as upland taxes after that case. So that was a case that the Supreme Court decided back in 2017. And it was only about the timing of an initiative being put on the ballot. But ever since that case has been decided, its holding has been expanded and expanded and expanded by the appellate courts. And the long story short is that there's now this sense that if you propose a tax as an initiative, you can just keep working around Proposition 13 and 218, and you can keep working around the rules. However, those cases were mostly about special taxes and whether you needed a 2/3 vote versus a majority. So we've been losing those cases, unfortunately. The courts of appeal have been saying that if you propose the tax as an initiative, you only need a simple majority instead of a 2/3 to get a special tax passed. So how does this relate to Measure ULA? I'll try to bring it back. The theory of the proponents that they're banking on is that because they presented Measure ULA as an initiative, they don't need to follow the rule against special transfer taxes either. So we had to prepare for that. Okay, so we knew that that was coming. We knew we couldn't just file our case and say, well, Prop 13 says no special transfer taxes, which we would have liked to do. As it turns out, the Los Angeles City Charter specifically says that an initiative may be adopted if the city council can also adopt it. So what that means is that the power of initiative in Los Angeles is coextensive with the power of the city council. And everyone knows the city council cannot pass a special transfer tax. And if the initiative power cannot do the same thing, then it also has to follow Proposition 13. So I'm sorry, that's a very roundabout explanation, but our case is Proposition 13 and the Los Angeles City Charter, which says that an initiative has to follow the same rules as the city council would. So essentially, Measure ULA is just illegal in its substance. And that's what we're going to be arguing to the court as soon as we can.
There's a similar lawsuit against the city of Santa Monica, but their charter does not have the same provision as LA. LA has this section in it, Section 405, which is a substantive limitation on the power of the initiative. And you know, when we first looked at this case, we were honestly struggling with a legal theory upon which to attack it to bypass the Upland decision. We thought about equal protection, due process, other provisions of law, but we came across this very unique provision of the LA City Charter, which provides a substantive limitation on the scope of the initiative power. So that's kind of our major hook. And, you know, I've talked to a number of attorneys who don't have a dog in this fight. They said, yeah, that's a pretty good cause of action. We can't predict a win because obviously the courts in California are trending very much to the left. But we feel that on the law, if it's applied on the plain language, we have a pretty good shot of winning this.
Great.
Yeah, you know, I'm not sure if this is kind of a redundant question, but I know several people have asked, you know, how is this lawsuit different from other lawsuits or initiative special taxes for homelessness and housing services, similar to the one in San Francisco, which the appellate courts up there rejected. I'm not sure if Laura answered that in her first kind of description of the Upland case.
I touched on it, but I know which case you're talking about.
Yeah.
Yes, the Supreme Court refused to grant review over that. So it's the Court of Appeal decision rested that that the homelessness tax in San Francisco was just fine. What makes that different than this case is that that case was about the voter approval thresholds. It was a special tax. And it was not a transfer tax on property. That's what we have here. We have a transfer tax on property. In San Francisco, I'm trying to remember, I should know which kind of tax that was in that particular case. There were so many, but it may have been a sales tax. It may have been something else, but it was not a transfer tax. So the only issue in that case was one that they decided was merely procedural, which was 2/3 or simple majority votes. We're not arguing about that here. We're actually going straight to the substance of the legislation itself. You know, in San Francisco, there was no question that you could have that type of tax. Here, we're saying this type of tax is not even constitutional. So the big difference is that those cases were deemed procedural. This case is about the substance of the legislation itself.
Understood. I appreciate you kind of clearing that up and describing the differences between the two suits. You know, share with us, what's the timeline for this lawsuit and where does it currently stand?
Yes, well, we were the first to file, and we filed our lawsuit back in late December. because it is a special type of lawsuit called reverse validation, we had to go through some procedures, including publishing in the newspaper. And we had to publish for 3 weeks. So the reason we have to do this is because this is, it's considered an action against all persons in Los Angeles who might be interested in the matter. So you have to get this jurisdiction over everyone. So we follow a series of statutes where we publish in the newspaper 3 times, include certain language. We had to post a deadline for answers. Any interested person can file an answer to our case. And that deadline is February 15th. So we've got 8 days left on that to receive answers from anyone who can claim an interest. Once that happens, then the court officially has jurisdiction over the matter. We've already served the city of Los Angeles and they've appeared, so we have jurisdiction over the city itself too. Once that happens, the case proceeds as any other case would. So starting February 15th, everything else proceeds as a regular case. That means we could do discovery, or we could go straight into filing a motion to ask the judge for a decision, which is something I very much hope to do. I can tell you that we will proceed as quickly as we can to get a decision from the judge.
This isn't going to be like
where we stand now. Sorry, John.
Was that John?
Yeah, this isn't going to be like a slip and fall, he said, she said, very few factual issues in dispute. So we have a couple of alternatives. I think one thing that Laura and I have talked about is proceeding with what's called a motion for judgment on the pleadings, which is basically, here are the facts. None of them are in dispute. Judge, you have everything you need to rule on this. Now, we may have to do some discovery, and if there are any facts that one party or the other contest, they can do what's called a motion for summary judgment. I don't see this going really to a trial type proceeding, certainly not with a jury. We're going to try to expedite this as quickly as possible. And just, I want to clarify one thing. When Laura talked about publishing, the thing that was published was the summons. It's called publication of summons, and that's what you have to do for these what's called 860 validation actions. And we're one of the few firms that has a lot of experience with validation actions, simply because we do so much litigation against local governments on fiscal issues, tax and bonds and those kinds of things. So this is not our first rodeo on these validation actions.
Gotcha. And what are your thoughts? Do you believe this could be resolved before the April 1st effective date?
I think I'll let Laura correct me, because we may have I think it's possible. I think it's unlikely, but because litigation rarely moves that fast. For any of you doing eviction law or anything like that, or any other litigation involving property rights, it moves very slowly. Now, there is a provision under the validation statutes that gives validation actions calendar preference. So that helps a lot. That helps a lot. So I think, Laura's doing everything she can to move the case along. Laura, I think you told me you had one conversation with a city attorney who seemed somewhat receptive to the idea of moving it quickly, but I was not a part of that conversation. So you can elaborate if you want.
Right. Well, first, like John said, we do have statutory calendar preference on the case. So that does give us a little advantage. Every time we're in court, we can say, hey, judge, remember, we have calendar preference. Can you please schedule our next hearing as soon as possible, instead of, next year, or what's happening in a lot of other cases that are, courts are still backed up from COVID. So we do have that. But John's right. I've also been speaking with the city attorney's office, of course, and the deputy city attorney that I have been communicating with does seem amenable to getting into court possibly before April 1st to have a hearing. But I'm also informed that they are hiring outside counsel. So there's a lot of unknowns still there. The firm that they hire to represent them could try to delay things, or they might just jump right in. They will be informed, I have to assume, of the intentions of the city attorney, as I understand them, which is, let's get this before the judge as soon as we can and get a decision. So me personally, I do have a little bit of hope that we might be able to get the trial level decision just before April 1st. I'm not going to promise anything, but I'm saying I'm trying to get that to happen. But even if that does happen, we all have to be realistic here. There will be an appeal. There will be no final decision for quite some time. There will be an appeal, then we get a briefing schedule from the Court of Appeal, and there's no way that that's going to be fast. And after that, of course, the losing side will probably petition the California Supreme Court, which is discretionary, and then we see what happens then.
Let me ask a question of Laura. If we get a favorable ruling in the trial court, doesn't that maybe not force the city to escrow the funds or get a temporary abeyance, but the city, if we get a favorable ruling in the trial court, if I were the city attorney, I would say, time out. We don't want to go through the administrative burden of having to return all this money to people, and maybe just hold it in abeyance. I don't think that's guaranteed, but I think if we get a favorable ruling in the trial court, that might help us with some interim relief. Laura, do you agree with that?
Exactly. That's why I'm pushing for it as much as I can to get a decision by the trial court before April 1st, because if we do prevail, it would make sense that things are held off, or at minimum that there is an escrow account where they are holding that money in case they need to return it.
Well, that brought me to a question. I have two questions. So you said something very interesting a little bit earlier, which I'll touch on in a second. But first was, if this is not resolved before the April 1st effective date, is there a chance that an injunction can be filed?
Unfortunately, no. Go ahead, John.
I hate to be the bearer of bad news, but California, like almost all other states, has what's called an anti-injunction provision in the state constitution, which basically says you cannot sue to enjoin the collection of a tax. The U.S. Constitution, I believe, has a similar provision. So it's one of those things that it's extremely difficult to get injunctive relief on. We've tried to work around that by seeking declaratory relief as well, but sometimes the court says, we see what you're trying to do here, but basically very difficult to get an injunction. There's a whole series of cases where like there's a statewide tax administered by counties where basically the courts have said, no, everybody has to pay, everybody has to file a claim for refund. They make it, in California, they make it extremely difficult to get interim relief on any tax.
Gotcha. And Laura brought up something that I want to touch on. She mentioned that the city attorney hired an outside firm to represent them in this case. Is that correct?
Yes, well, they're in the process. That's correct. They're in the process of that. So we don't know who our opposing counsel will be.
Is that normal?
Yeah.
It is, but I'm surprised they're taking this long to do it. They've known about this case since late December.
Mm-hmm. Interesting. I would think the city of Los Angeles had resources to fight their own cases, but I digress.
I believe they do.
Yeah.
So if Measure ULA is thrown out by the courts, if we get a victory here, can the city come back again with the same thing, repackage it differently, call it a different name? What are we looking like on that end?
If the city does that, if the city itself does it, it would need a 2/3 vote. There's always the chance that some other group, some other so-called citizens group could come out and try to exploit the Upland decision again. But I'm not sure we're there yet, but keeping that before we close today, let me talk about the Taxpayer Protection Act that we're working with the California Business Roundtable on. It is qualified for the 2024 ballot. It has a reach back provision that would essentially nullify ULA. It would not stop it, but it would say if you want to keep collecting the money, you have to get the tax ratified by a 2/3 vote in a subsequent election. So we designed the Taxpayer Protection Act specifically to deal with these upland cases, and we had a reach back provision to January 1st of 2022. So a lot of these taxes that have exploited the upland exception would have to go back to the voters.
I think
And
CoStar.
I think,
just put
yeah,
out an
Ray and I
article.
touched on that earlier. We saw that this new tax provision measure will be on the ballot in 2024, which I think we were all very excited to hear. And I
So-
think Ray did a little bit more reading on it.
Yeah, we'll touch on that right at the end, but if the courts uphold Measure ULA, can your group appeal the decision?
Yes.
Yes.
Oh, yes, we will.
Okay, fantastic.
And is that a plan? Because I know, unfortunately, a lot of our courts, especially here in Southern California, tend to find justification to not how do I put this? To find justification for not following the law at times. They might be activist courts, activist judges, so on and so forth, that, even though it's pretty clear what the law states, they tend to ignore it. Is that a fear of yours here in Los Angeles?
I think it's always a fear. The Los Angeles is in the Second District Court of Appeal. The first is San Francisco, which I characterize as the worst. There are other ones, Central Valley, the fourth, and San Diego. That I think it's a roll of the dice. It's just all we can hope is that the justices look at the law and apply the law to the facts of the case. We can't ask for more than that. I will say that both Jerry Brown and Gavin Newsom have appointed no Republican judges in their tenure. They've all been Democrats or independents. Now, some of them are good. I'm not going to say this is it's a breakdown on by party affiliation, but sometimes a lot of the appointees from Gavin Newsom come out of academia or labor organizations and not the private sector, which is not usually a good sign for us.
Gotcha.
So outside of money and the information you guys are sharing in the chat here, how can we really want to activate people, right? Because it's really easy to complain and sit back and be passive and let things happen to you versus stepping into power, taking action, getting behind groups such as yourself to advance an argument as to why some of this stuff really may not make a lot of sense. So how can property owners, how can real estate agents, how can special interest groups outside of money, is there any other way they can support you against the kind of fights that you guys are fighting on behalf of the real estate community?
Absolutely.
That's a Susan question.
The best thing to do, if you don't want to write a check right now, the best thing to do is to join the Howard Jarvis Taxpayers Association, be a member of this great organization, and we will keep you up to date on all these things that are going on in the legislature, in the courts, on the ballot. So go to hjta.org and click join us and sign up for the email alerts. And to be a member, it's only $15 a year, and we will let you know about all these things that are going to cost you money if you don't pick up the phone at the right moment and call your city council representative or your legislators and tell them that you're aware of this, because many times they want to slip things through. They want to call it funding, not taxes. They want to call it a framework, not a wealth tax. Many times you have to have translators to explain what they're doing to you. And some of these things are on a long fuse. They'll pass something and the price tag hits much later and it's too late then. So we'll
Right.
keep you up to date. We'll keep you on the front end of these things so you can do something about it. HJTA.org.
So if somebody joins and becomes a member, is there meetings or is there a community base that's coming together? So maybe even if somebody has skill sets or a background that might be helpful in advancing your agenda, do those types of events happen?
Well, we're always willing to have people come in and volunteer if we're collecting signatures or if we're working on something for a campaign. We always appreciate having volunteers and people who want to spread the word and share the information and hand out flyers to their friends or download flyers from the internet and pass them out to people. So yes, but the best way to stay connected, we don't have regular meetings or anything of that type. There's no time commitment. But
Sure.
if you become a member, you will automatically be notified of everything we're doing. And it is always beneficial to property owners because we're focused primarily on property taxes and property related taxes, and
Great.
all taxes really, but particularly property related taxes.
Awesome.
And if there's a
So-
if there's a for larger donors that want in-person presentations at either luncheon events or dinner events, Susan and I are always willing to attend those. So sometimes we give political presentations. A lot of Susan does a lot of Republican Women Federated. I've spoken before BOMA several times and commercial real estate interests throughout California. So if there are any events you've got coming up and want a partial briefing or a full presentation, we do a lot of public speaking, and we have I write a column for the Southern California News Group. That's 11 newspapers in Southern California. It's every Sunday. You can keep up to speed that way. And our website, as Susan mentioned, HJTA.org, has a lot of resources on it. I mean, a lot. So one thing people can do is just peruse the website. Things like how to do a Public Records Act request, how to repeal a utility user tax, just tons of information on there that a lot of taxpayers find very, very useful.
Right. So before, thank you for that. Before Matt jumps into taking questions from our community here, I think it's always important to set expectations. We're used to setting expectations for clients, right? And I'm sure you folks like to operate the same. So despite some of the good news we saw from the CoStar article and the signatures that were gathered in 2024 to really kind of challenge these things and overrule them, hopefully, as it pertains today up until April 1st, would you agree that real estate agents, real estate investors, homeowners who would be impacted by Measure ULA need to plan that more than likely they will have to pay that tax if they're in escrow or if they're going into escrow come April 1st? Because that's really kind of what a lot of people care about right now, right? Like if they're going into escrow, should I be like 80%, 90% that I'm going to have to pay this tax? Like, how would you set expectations with people today?
Well, I would say be prepared to pay the tax.
Yeah.
Laura, would you agree?
Yes, be prepared to pay the tax. Sorry to have to say that, but yes, be prepared to pay the tax. Also be prepared to file a claim for refund within a year of your close of escrow. And for me, I just get it filed right away after the escrow closes, so I know it's done. But you want to get your claim for refund on file so that when the dust settles and hopefully we have prevailed at the very end of the case, you have your right to get your refund back. Because generally tax refunds go back 1 year. So preserve your rights, get your claim for refund on file after you have to pay.
And we can help with the drafting of those claims for refund.
Yes.
Yeah.
And
If
those refunds are issued, are those going to be held in an interest-bearing account? Because if you have some people that have millions upon millions of dollars sitting static in a city account, not operating for themselves, not generating any money for themselves as they would have if they placed it somewhere else. Is the city going to be liable for that if this is overturned, or is it just kind of a wash? Here's your money back. We're sorry. Have a great day.
I haven't, Matt, I haven't researched this, but my assumption is that legal interest, like any other litigation matter, would apply. That's my guess. I have not researched this in this particular context, but I think it would.
Gotcha.
I'm sure you guys will definitely fight for that as well.
Yeah.
So before Matt opens it up to questions, Laura, I really valued your answer right there at the end. If you could put that in the chat for our listeners and for us to share later, that would be amazing, because the reality is like, hey, expect to pay the tax, but it's not hopeless yet, because this could get overturned and there could be an opportunity for you, at the very least, hopefully, to get your money back. So I think that the world needs to know that. So if you would please put that in the chat, I would greatly appreciate it. And Matt, I'll turn it over to you now for questions.
Well, just to kind of pick up where Ray left off, I mean, that's extremely important. We have several clients we're working with that are selling their buildings that are going to incur that 4% or 5% transfer tax. We have certain individuals, unfortunately for them, that they're over leveraged in their buildings, and their buildings are no longer worth what they owe on the property. And I'm curious, before we get into this, I'm curious at how that's going to work, because we're dealing with one client. He owns a significant property. His debt is well over the value of the property. So what we're trying to do is just make the creditors whole. What happens at the end when escrow is trying to reconcile this account, and you have three creditors in line, but the transfer tax is going to eat up some of those proceeds? Is the city in first position when it comes to this?
If it's in bankruptcy, we all know that government gets first claim. If it's not in bankruptcy, yeah, government usually gets the first claim. So I think they're going to be standing right there at the front of the line. I don't see why that the regular rule would not apply here. And again, that is one of the arguments is that in those situations, even if it weren't facially invalid, facially unconstitutional, someone argue that as applied to that person, that it was somehow a taking without just compensation? I don't know. I tend to doubt it, but I mean, in that situation, someone might be able to get relief on some narrow lawsuit, but I don't know whether Laura would agree with that. But I wouldn't count on that.
Yeah, gotcha. Now there was a few questions. One person asked, have you received any opinions of outcome of this suit? I know you mentioned earlier that you had shared it with some other legal minds here in the city. They said, yeah, you got a strong case here. Could you maybe go into more detail on those?
Just the people that have looked at our lawsuits, and then they looked at situations like Santa Monica and others. They've kind of said, "Oh, you guys have a really good hook." Now, can you take that to the bank? I don't know. The proponents of the thing are going to come up and they're going to be waving that upland flag. They're going to say upland applies, and we're going to say no. This provision of the LA Charter makes it clear that your ability to advance this initiative is restricted to what the city council itself could do, and they couldn't do it. So our argument is extremely logical. Whether or not the court will buy off on it, we don't know.
Gotcha. And another individual asked, how will the signatures that are gathered to put Taxpayer Protection and Government Accountability Act on the statewide ballot in 24 affect ULA? I think you might have answered that, but maybe clarify again for them.
Sure. We had 1.4 million signatures. It has just this past week, it qualified. It probably would have qualified a lot earlier, but the registrars of voters asked for a little bit of a delay, which we granted them because they were processing all the votes from the last election cycle. And they probably could have applied for extension with a judge and gotten it anyway. And it doesn't really affect us because we knew it was going to qualify, and we know it's going to be on the 2024 ballot. So I've already got meetings set up for this week, laying out the campaign strategy for Taxpayer Protection Act. But again, in the context of ULA, it does have this reach back provision, which I think the consensus is will have a dramatic impact. It may not allow people who have to close escrow while ULA is in legal effect, because even if TPA passes, that doesn't mean that if it passes, and let's assume we lost ULA. Actually, I'm going to use a different example. Let's use a upland tax that's not ULA that for some reason the lawsuits had lost. Would the Taxpayer Protection Act give a right to refund during the interim? The answer is no. All the Taxpayer Protection Act would do is say the tax could only be continued to be collected up to the point where it's ratified by a 2/3 vote of the local electorate, and that's what we're shooting for. Our hope is we win ULA, and so TPA's applicability is a moot point, because if we won ULA, obviously we've won. But we want to proceed on both fronts, obviously.
Yeah. And I know from the last year, 2 years, that citizen-based initiatives that they've tried to get onto the ballot have gone through certain audits within the registrars. Are you officially confirmed that you've acquired enough signatures for this to be on the ballot?
Yes, we got the certification from the Secretary of State.
Wonderful, wonderful. Let me find another question that someone else had. I think they asked, Ray and I, when Measure ULA was passed, we read it cover to cover. And we saw some things that a lot of the people appointed had to meet certain qualifications, whether they were I don't know, what would you call it, a street activist or an activist to sit on the board. They had to have some homeless. Do we have clarity as to their compensation and where this money is going? Because I know a lot of us, when we were dealing with, what was it, AB 1482, or other homeless initiatives, money disappeared. There was no accountability.
Yeah, you're referring to Measure HHH.
HHH, thank you, Ray.
Yes, the Measure ULA has, I believe it's 8% of the revenue that's collected can go for administration, and there's a stipend that's specified for all of the board members, and then there are consulting contracts that can be awarded, and I don't know what their conflict of interest rules will be on who can get the consulting contracts, but there's no question that the people who put this on the ballot directed the money essentially to the types of organizations that they were. And and this is one of the problems with having a special tax approved by a simple majority vote under this upland loophole. People can put something on the ballot that directs the money to the people who put it on the ballot, whether it's a union seeking a pay raise and they direct the money to themselves. It must be spent on salaries. They can do that. And if they can convince a majority of the voters to pass it, and that's enough, because you don't need a 2/3 under this loophole, then we could see this on every ballot. And indeed, we have seen this on every ballot. Not all of them have passed. Some of them have really gone down in flames. But this is an opportunity for slick marketing to get it just over 50% and direct the money to the people who paid for the signature collection to get it on the ballot.
Gotcha. And I have a question, because you brought up a good point, marketing, slick marketing. There's a lot of special interests that have deep pockets that can spend their way into the winner's circle on almost any debate. When it comes to the 2024 ballot measure, are you guys funded enough to make this a fight with voters?
It's never enough. If everyone would like to help, you can donate to John, I'll turn it over to you. Where's the best place to donate to support the Taxpayer Protection Act?
Well, we have our own initiative committee. It's called Protect Prop 13, and we have two initiative committees. So I think there's the information on our website on that. We can provide you with some more clarity on that. Also, the what I'll call the umbrella committee through California Business Roundtable. There's a committee there. I'm on the executive board of that. Either of those committees is very good. So, but you can go to our website. Again, we have two initiative committees. One is called No New Taxes. One is called Protect Prop 13, and this would be Protect Prop 13. So we can provide you, Matt and Ray. We can provide you with that information for you to get out.
Fantastic. Look, I think we've covered most of the questions, and we covered a lot today. We'll obviously be sharing this on our website. We'll send you the video. You're welcome to share it wherever you like. We're very, very grateful to all of you and to your organization for fighting on behalf of real estate owners, real estate investors, trying to make sense out where tax dollars are going. But, we're really grateful. I think the big takeaway for me today, and it could be similar for others, but I think the time is over for being passive. If you're a real estate agent, a real estate broker, a real estate investor, a homeowner, you need to be active in all manners concerning real estate. We can't be passive anymore. We can't put our head in the sand, and we can't fall into that hopeless category. LA is a great city. There's a lot of great reasons to own real estate in LA still and to invest in LA. And we really need to build upon the efforts of groups like yourself. So thank you all, so very much for joining us today, for sharing the valuable information. If you're in escrow right now, or if you're thinking about selling a property, we can still get it sold quickly before Measure ULA passes. If you close after, the takeaway today was expect to pay those taxes because the likelihood of this getting defeated prior to the deadline is more so on the lower end. However, as Laura shared, save those records so that you could apply for a refund if it in fact does get overturned. That was super powerful, and it still really kind of takes us away on a positive note that there's going to be a chance to get that money back if it does get overturned for the people that's all, and get impacted by that. So unless anybody has anything else to say, I'm just saying thank you very much, and that's all from my end.
Thank you.
Yeah, I'd just like to thank all of you. Susan, I will say she put this all together. I reached out to her a few weeks back, and I'm blown away by what she was able to put together for everybody that's listening, and really she deserves a round of applause. Thank you so much.
Thank you very much
for scheduling all this, and we're deeply appreciative, and the information is invaluable.
Well, we're here for you. You can call our office in Sacramento. You can call our office in Los Angeles. I put the phone number of the LA office in the chat. You can call us if you have questions. You can email me at susan@hjta.org. Happy to answer your questions. And we're going to hope for a good outcome. We do have something called calendar preference for this type of action because it's a validation action. I don't know how much that helps us, but it does move things along faster than other types of cases. So we're optimistic that we will get a decision sooner rather than later.
Fantastic. Once again, thank you, folks. Have a wonderful day and continue the good fight. We appreciate you.
Thank you.
Guys.
Take care.
Thank you very much.
Bye.
Bye.